What is good? What is good? Doc Motivated hitting you again. It's been a while. Doc Motivate is in the building. All right, so we're going to make this a short video today. Okay. So, most people think that the word verified means that the bank is correct, right? So, when you get that verified letter saying that we verified um, this account, the account is correct, basically shut down what your disputes are, right? So legally, that's false, right? So courts have ruled verification must involve underlying documentation, not just a data confirmation, right? They have to have correct documents. It must be 100% accurate, right? You can look at the Cushman versus TransUnion, the Dennis versus BH1, um, Henson versus CSC Credit Services, right? And you can look at that and it will show you that verify doesn't mean that it's actually correct. So don't stop your credit disputing process just because you see the word verify, right? Keep in mind that most credit reporting agencies are procedural, right? The majority of deletions happen because missing wet signatures, incomplete account histories, wrong dates, balances, or status of the account, inconsistent reporting against all three bureaus. TransUnion is different, Experian is different, Equifax is different. They're not reporting the same information, right? Failure to note the dispute, failure to notify on the credit file that consumer disputes this account, right? Late or no responses within 30 days. That's another one. All these can potentially be CFPB complaints, also, right? These are compliance failures, not emotional arguments. Consumer law attacks processes, not feelings. Excuse me. So, what we do here at the Upstream Life Group, we do factual disputing, right? And yes, we do use consumer laws, right? Doesn't a lawyer use consumer laws when he comes into court or she comes into court? Yes, they do. Okay, so when the bureaus ignore proper disputes, right, they can face charges. They can end up paying you monetary relief. Statutory damages on 15 USC 1681N, right? Punitive damages, right? Attorney fees, printing fees of even down to how many pages did you have to go print at the library, right? Strong disputes get results. Weak generic disputes get ignored. You're not asking, you're putting them on legal notice. That's why you're referring back to the codes, right? United States codes. You're referring to UCC violations, all that. You're using uh, old court cases, old documentations that actually won in court, right? So now we're going to go to why most people fail and law-based disputes win, right? Why most people fail with their dispute and why law-based disputes win. Most people dispute emotionally, right? They get mad. They tell you about their situation. This, and it just goes AWOL. Their CFPB complaints are emotional rather than right by the book, cut and dry. This is what you want. Delete it right now. What will be a fair resolution? Delete it or pay me, right? They'll upload screenshots. They'll argue fairness, right? And what this does is it creates and triggers the automation, not accountability, right? Law-based disputes, like how we use, cite specific statutes, demands proofs, not options, and create paper trails of you asking them that, right? Set up regulatory litigation exposures that they're not abiding by, that they're trying to finesse you, right? So these are some of the reasons why we do indeed use uh, old laws and things that we research along with factual disputing. We do factual disputing, but we also have no problem with using some laws. So the bottom line is consumer laws work. Why? Because it forces proof. It shifts the burden. It exploits compliance gaps. It creates liabilities and it leaves no room for shortcuts. Okay. Credit repair isn't magic. It's law, timing, and pressure.